Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 29th of April, 2025, a new document was dropped onto the docket for public review. It is a 12-page document. It is an order denying the defendant's motion to strike the DP and adopt other necessary procedures. I will leave you to pull this document off the docket and read it in its entirety to why Judge Hippler has denied this motion flat out. But let's just do a little bit of a background and a synopsis here. It says here under the introduction section, page 1, defendant contends that the discovery produced by the state in this case has been voluminous and unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for trial. Asserting his due process rights have been violated. Due process is guaranteed by the 14th Amendment to the United States Constitution, ladies and gentlemen. So when he's asserting his due process privileges have been violated, Mr. Koberger is saying that his federally protected privileges under the 14th Amendment to the United States Constitution have been violated. This order goes on to say, line 4, page 1, defendant seeks sanctions in the form of striking the DP and imposing certain organizational requirements upon the state to aid defendant's review of discovery. There's a footnote 1 here. It says here, defendant also moved to strike the state's experts, incorporating his motion in limine regarding vague and undisclosed expert witnesses. The court denied this motion in a separate order. Going back up to the body of this order, we're still on paragraph 1. The state responds that it has complied with all discovery obligations, including Brady, and there is no basis for sanctions or other measures. There's a footnote 2 here regarding Brady. This is a United States Supreme Court case, Brady versus Maryland, and you can find it in the U.S. Reporter at 373 U.S. 83, 1963. In other words, this is a U.S. Supreme Court case from 1963. Next paragraph. Oral argument on the motion was held on April 9th, 2025, after which the court took the matter under advisement, meaning the court did not make any sort of a ruling on this matter at the hearing. Taking it under advisement means that he took the briefings, the motion, the response, reply, and the arguments made of both sides under advisement. Here is his ruling. Because defendant has failed to show a discovery violation or a due process violation by the state, sanctions are not warranted. The court further declines to require the state to provide further organizational assistance to defendant. If you look at the bottom of page 1 under standard, this is the legal standard regarding certain of the issues that have been raised here. It continues on into page 2. It discusses the Brady case. Then it goes into the next several pages, applying the law to the fact pattern here. And then ultimately, if we go forward to the last page of the written order itself before the certificate of service, page 11, section 5 order based on the foregoing defendant's motion to strike the DP and adopt other necessary procedures due to the state's disclosure violations is denied. So now we see yet another in a long line of motions, attempts for the defense to strike the DP, to get it off the table, to get it off from consideration if the event of a conviction, have all been denied. This dates back to October of 2024 when there were a slew of motions to strike the DP. There was another motion in limine to strike the DP, all denied. This is also a denial. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.